special education. So special education is one of the most complex areas of education policy and law we're going to deal with in this committee. In the United States, the three most important laws to have some sense of and understanding it are Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and most importantly, the Individuals with Disabilities Education Act, called IDEA. This bill relates to provisions of IDEA. Under IDEA, students with a disability are entitled to the development of what's called an individualized education program. That program is determined in a plan called an IEP, an individualized education plan, that according to federal law is supposed to be determined by a group made up of folks from the school system, teachers that teach the student, parents, even in many cases, particularly as students enter the higher grades, the students themselves. And those plans include things like, identifying what that student's goals are in relation to their disability, identifying what specific accommodations that student is legally entitled to. In the majority of cases, the plan that's developed by the school system and the parents is a plan that everybody agrees on. In the minority of cases, there is disagreement. And those disagreements can often be challenging to work out. And federal law, IDEA, lays out three options for parents in that situation. One, they can file a complaint with the State Department of Education. Two, they could go to mediation. Three, they could enter a judicial process, which is often referred to sort of colloquially as due process. It's a hearing that in Maryland is done in front of an administrative law judge from the Office of Administrative Hearings. And for a number of years, this committee has been grappling with the entire special education process, but in particular, the question of how to make sure that due process is fair to parents. So, House Bill 140 relates to the awarding of fees in cases that go to due process. Under current Maryland law, there is a regulation that allows the awarding of attorney's fees. So that exists, but is a regulation and not law. However, because of a Supreme Court decision a number of years ago that said that IDEA does not mandate that judges be allowed to award experts' fees, parents can't be awarded experts' fees. And that is a fundamental inequitable flaw in the process. Here's why. School systems have experts. They're employees. They have in-house experts. For a parent to bring an expert in this kind of case costs thousands of dollars. I've talked to parents that have had to raid their retirement funds to try to get their kid the education they think their kid needs. And that seems to me to be utterly unfair. So the goal of this bill, which would allow judges to award experts' fees and attorneys' fees in these cases, is to make sure that parents are not at that financial disadvantage, that the process envisioned by IDEA that gives parents the legal right to contest what the school system is trying to put in an IEP, that process is equitable. And I would encourage a favorable report on this bill.
Next, we'll have Marla Posey-Moss.
Thank you. I'm Marla Posey-Moss, representing the Maryland PTA on behalf of Letitia Corey, our president. And as stated earlier, Maryland PTA is the largest child advocacy organization in the state of Maryland. Maryland PTA overwhelmingly supports House Bill 140 as it underscores a broader issue of the inability and challenges school systems have in fulfilling the individualized education programs of our public school students. Parents, particularly those who either lack the sophistication, family supports, or knowledge regarding their rights, simply don't have the opportunity to fight their way to a judicial proceeding. So costs for them far outweigh the legal costs that this bill is trying to cover. The core reason why there's a judicial proceeding in the first place is that there's a reasonable suspicion and doubt that an IEP is being adhered to by school jurisdiction. And oftentimes, MSDE finds that school systems do violate the IDEA or policies related to IEPs. Yet, the amount of energy and time endured that parents use to simply fight at the local level is so substantial that few people are able to make it to the level of an MSDE complaint or an administrative hearing. Hence, this bill simply touches the tip of the iceberg on the vastness of problems that children with disabilities have in Maryland public schools. A common observation is a systemic culture of non-compliance of school systems that result in many students not receiving proper supports due to a variety of alarms, such as a lack of early intervention and identification, deficiencies in teacher training, and insufficient instructional resources. These things are very real. If you speak to a variety of parents statewide, as I have, Harford County, Frederick County, Montgomery County, Anne Arundel County, Calvert County, Charles County, they share the same or continuous concern that in their IEP meetings is being dragged out, and it's an obvious problem to the point of them simply giving up an exhaustive attempt to get their child identified with a disability, tested for early intervention, obtain accessible tutoring, and ultimately the necessary supports to help them learn, as opposed to being passed on from grade to grade with significant deficiencies in their education. While Maryland PTA is an advocate for parents, teachers, and students in the Maryland public schools, we recognize that we have a long way to go. It isn't good enough to have a child continue matriculating at an either repeater grade or be forced to go to an alternative school. It is unacceptable to believe that just because a student gets good grades, they don't have an IEP or a disability or even deserve IEP testing. Where students live, particularly in rural areas, it also makes a difference in terms of access and affordability to certain resources needed for students with disabilities. Maryland PTA wholeheartedly supports House Bill 140 because parents should be provided back their legal and expert witness fees for cases involving special education proceeding. The time is now to adequately train our teachers, adequately fund our budgets to meet resource needs of all students, and the time is now to stop denying our IEP students their legal right to a free and appropriate education. Please support House Bill 140.
Thank you. We'll have up next Leslie Margolis.
Thank you. Good afternoon, members of the committee. My name is Leslie Side Margolis. I am a managing attorney at Disability Rights Maryland, and I chair the Education Advocacy Coalition, which is comprised of more than 25 organizations concerned with education policy in Maryland. You know, at the heart of it, this bill is about access and equity. As Delegate Lukey said, the Individuals with Disabilities Education Act guarantees a free, appropriate public education to children with disabilities. And Maryland has a state law that almost is identical to the IDEA, but has several differences. The IDEA sets out a number of procedural protections to ensure that kids have access to that free, appropriate public education. And one of those procedural protections is the right to challenge the education or any aspect of the education if parents disagree with it. But that right is meaningless if parents are unable to have the attorneys or the experts they need in order to do that. One of the striking numbers, I think, for you is to know that for the last 5 fiscal years, no unrepresented parent has succeeded in a due process hearing at the Office of Administrative Hearings. And it also is important to know that whether parents are represented or not, school systems always have a lawyer at a due process hearing. So unrepresented parents are going into due process hearings and they are not winning. It is also important for you to know that no parent without an expert has prevailed at a due process hearing. Parents have the option if they lose a due process hearing of going on to court, and the IDEA says they can go on to federal court or they can go on to state court. The IDEA has the attorney's fees provision saying if a parent prevails, the parent can get attorney's fees, but in the education code, we don't have a similar attorney's fees provision. So what House Bill 140 would do is allow parents who prevail at a hearing or who go on to go to court in state court and get attorney's fees. And it would also allow parents to recoup the cost of experts. You know, at Disability Rights Maryland, we do not charge for our services. Most of the clients we represent are very low income or barely above very low income. They cannot afford experts. So when we're looking at how to represent families, we feel like those families don't have the full range of due process protections guaranteed to them under the law. The IDEA was not supposed to be based on people's income. It is a guarantee to all children for a free, appropriate public education, and House Bill 140 is a way of addressing that. The Supreme Court has even labeled experts as firepower and said parents need the firepower to match the opposition. Thank you.
You. We'll next have Sarah Davis.
Hi, my name is Sarah Davis. I am the founder of Parent Advocacy Consortium, a grassroots organization that is supporting the civil rights of our children with disabilities. I'm also the parent of 5 children with a range of disabling conditions, including autism, cerebral palsy, dyslexia, and a host of other challenges. So imagine this. You are the parent of a child. You have determined based on doctors' opinions or lack of progress that your child is not making the right type of educational progress. And after years of going through this emotional process of realizing that your child is not getting what they need through the public school system, you take on the burden of accountability. You decide you will take the school system to due process in order to enforce your child's right to a free, appropriate public education. And after the agonizing experience of that, of going through the court system, the hours and hours and the emotional toll that this costs on families of marriages falling apart, etc., you prevail. And then imagine that you still walk away with $15,000, $20,000 of expert witness fees that even though you enforced your child's rights, you cannot recover. This is a fundamentally unfair policy. And the impact of this unfair policy is parents who do not have that type of resource are not able to enforce their children's rights in the first place because they don't have the money to be able to take over this cost that they have no hope of recovering. And so our children's rights are subverted. And in fact, the rights of our most disadvantaged students, our children who are facing not only disability, but also economic disadvantage and perhaps other types of disadvantage coming from those types of communities. My family has experienced Anne Arundel County Public Schools taking my family to due process, and I can tell you from that experience, it is one of the worst experiences a family can undertake. Recently, this year, my youngest was removed from an IEP. I don't have the money to be able to go out and retain the right types of experts to fight for my child's rights. And so we will move forward without the proper protections based on the documentation from a variety of experts in the area, from Children's National, from Mount Washington, from the most respected experts in the field. My child will not get what she needs. So I urge you as a committee to right this fundamental wrong and ensure that in the few cases that parents do actually go to due process, that they have what they need to be able to demonstrate what their children require and they can effectively protect their children's rights. Thank you for your time and attention.
Thank you very much. Any questions? Delegate Hornberger.
Thank you, Mr. Vice Chair. It seems like the idea here is that, and this happens in higher ed too, in a perfect world, you would have a full judiciary process and the parent wouldn't be going into the situation feel like they have a stacked deck against them. So my question is, we obviously can't have a court system within the school, right? Does this get us one step closer to what you would consider to be a fair judiciary process?
It gets us closer to a fair process. The process set up, the whole due process hearing process is required under federal law.
Okay.
So that exists. This is just adjusting that process to make it a little bit more fair. Frankly, I wish the federal government would fix this. I think, it would be nice if Congress had acted to fix this after the Supreme Court decision, because I think personally that this was the original intent of Congress in IDEA. But that is not the current federal law, so we need to fix it at the state level.
Yeah, because I know that other parents have talked to me about this, and they said once they start getting involved in the process, they reach this point of no return where they've kind of relied on the school to give them advice on which direction to go, and now they're too far in, they can't back out, and as a result, they have to go this undesirable route where some sort of mediation could help.
And there are times when parents are brought to due process by the school system. So sometimes parents find themselves, as Ms. Davis did, facing hearings. It's not always parents initiating the hearing. So Congress has a couple of times over the years since the Supreme Court case brought legislation to attempt to overturn the Supreme Court case. Congress being rather dysfunctional over the last number of years, things have not moved forward with the federal legislation. So this is a bill to try to do that. And I do want to stress that it is reimbursement of experts. So parents have to get through a due process hearing, and they have to prevail. All that this bill would do is maybe give parents a shot at finding an expert who would be willing to work with them, knowing that there is a possibility of getting fees if the parent prevails. So it's the possibility of reimbursement. Right now, so many experts say to parents, there's not even a chance I'm going to get paid. If you can't pay me up front, I can't work with you.
Gotcha. All right, thank you.
Lukey, how close is this to the burden of proof? I mean, we've talked about that and tried to get there. Can you just relate this to the burden of proof and how that works?
Sure, this makes no change in the current burden of proof in state law. Sure, Mr. Vice Chairman.
Yes, Delegate.
Thank you. So following up on the point about this being reimbursement after experts are paid, I mean, so from an equity perspective, it's going to make the gamble a little bit feel safer maybe for folks who have the means to take that gamble, right? But it really doesn't open up the opportunity for families who don't have the funds to risk not being reimbursed.
No,
Is
it
that
does.
correct?
It does
Or
because there are experts who might be willing to work on a contingency fee. So there are experts who, knowing that there is a possibility of getting paid if there were a reimbursement provision, are maybe willing, and we know that there are some who would be willing to work with a family who is not able to pay them up front, rather than families having to pay.
So we're relying on the altruism of the experts willing to take
And
the
there
work
are-
at that risk.
and
Is
there-
that
Yes, and there
sufficient
are
supply?
some. There definitely are some, but the fact that there is no possibility of reimbursement right now is a non-starter for a number of people.
All right, thank you.
Thank you, Mr. Vice Chairman.
Oh, wow, I didn't know we can do it myself. Thank you very much. All right, right? There we go. All right, next we'll have up Dana Bergman. Okay. And also, we'll call it right now also Andy Cope. Nope, not here. Okay. You can start.
Greetings. I'm in favor of House Bill 140. My name is Diana Bergman, and I'm a parent of three very unique special boys who receive special education services. We're a mobile military family. My husband, 15 years of service, being stationed in Maryland for the last 8.5 years. In 2011, our family went through our first mediation process with Anne Arundel County Public School. Our son, nonverbal child on the autism spectrum, had not received any individual family special plan service, an IFSP, or special education services for 4 months. The school system failed to acknowledge the IFSP the state of California had provided us. At the time, we had support from our military system to help us, and still, our son did not receive access to services. I told my husband we either take out a personal loan for a special education attorney or we move off post to a new school district. Our first Christmas in Maryland was spent at Patterson Park in Baltimore City, thanks to ACS and our EF&P facilitator. We received bags of toys for our young boys. We felt bad. We watched children hop on the city bus with their bags of toys, and our family was in similar financial hardship because of our son's disability. We made the difficult decision to move off post and move to Baltimore County. At the time, for a junior NCO, family of 5, our family budget was very tight. We had a coupon clip like you see on TV, and we barely had enough money in our savings account. I was able to start working in 2013, and by February 2017, our biggest battle began once again. Our family had around $15,000 in saving. In April of 2017, I had to quit my job. My husband was deployed, school is not implementing my oldest 504 plan, refusing to meet for an IEP. And my middle child had the worst of the situation, and my youngest started with anxiety. Worst of all, the financial hardship once again. Hire an advocate, a special education attorney, and no extra income. We went through our usual military supports. We found out, sorry, Ms. Bergman, we were told families can no longer have the military school liaison at an IEP meeting. $15,000 in savings, and the average due process here will cost $50,000 for only one case. It's obvious that I did not have $150,000 to represent our children. I only had $15,000. And how do I convince someone to represent my children knowing that I don't have enough money? Good thing, people like me and creativeness, not really. People expect to get paid for their services. And I filed for mediation for all three boys, never-ending files all over the dining room table. I became a surface abuser, countless hours on the phone, writing to everybody and their grandmother. Results, one child received non-public placement. One child finally received an IEP. And my youngest is still testing, waiting to hear back on Schedule T.
I'm going to ask you to conclude, please.
Sorry. So in conclusion, the Bergman's family savings account is at zero. Absolutely zero. $150,000 to represent three boys with special needs. I owe less on our house. And we're never going to see that money. But imagine those kids that spent Christmas in Patterson Park. They don't even have a chance.
Thank you, Ms. Bergman,
Thank you.
for sharing your story with us. Wait 1 second. Are there any questions of this witness? Seeing none, thank you, Ms. Bergman. Thank you again for sharing your story. All right. We'll have a next panel up in opposition. We have John Willems, David Burkhouse, Renee Spence, and Sally Farr. And as you get up, you can just start.
Mr. Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education. The committee has my written testimony, and Delegate Lutke did an outstanding job providing a background on the overall scheme of the federal special education law. Mabe's testimony emphasizes a couple things that I just want to mention briefly. One is that local boards of education and individual board members, based on my considerable experience, place a very high priority on delivering high-quality services to our special education community, the parents and families with students receiving special education services, including the disability services under the 504 plans and the IDEA services under the IEPs. And many of our board members are parents and parents with experience in this area. And so our conversations and deliberations on these issues are always very thoughtful and in many ways heartfelt in ways that other issues do not generate. I bring that up also because we just spent a day on the Hill visiting members of our congressional delegation, and the National School Boards Association has launched a campaign in favor of the prompt reauthorization of IDEA with an eye toward developing a federal law that is less prone to adversarial litigation-oriented dispute resolution. And so I want to emphasize that as well. And lastly, I want to thank the General Assembly for their attention through the Kerwin Commission to the costs imposed on school systems now and the pending recommendation to increase special education funding by more than $500 million. However, that funding is far from being a reality or coming to fruition, and so would urge a consideration against imposing any significant new cost on school systems in the area of special education at this time. And as I said, the committee has my written testimony, and Mabe is asking for an unfavorable report on this bill.
Thank you. Mr. Burkhouse.
Yes, thank you. My name's David Burkhouse. I'm an attorney, and I practice in the area of special education law. I represent several school systems, and I'd like to address my my comments specifically to how the statutory language in House Bill 140 would change the current framework under which due process cases are resolved. Many civil rights statutes provide that a prevailing party can recover their attorney's fees. The IDEA is one of those statutes. There is already an entitlement under federal law. When parents prevail at these administrative hearings, they're entitled to petition for prevailing party attorney's fees. This requirement exists both in federal law, it exists in federal regulation, and it's been incorporated in the COMAR as well under Maryland regulations. What House Bill 140 would propose to do would be to move the determination of what those prevailing party fees are into the administrative hearing itself. OAH would be tasked with determining how much the parents' fees are and whether or not they're reasonable. This isn't a great idea, and the reason it's not a great idea is because it turns prevailing party fees into an issue for litigation in every single case. Indeed, it would probably expand the amount of time required to try a due process case by an entire day. That litigation is not necessary in many cases because prevailing party fees don't become an issue. It's simply a fact that parents are not going to prevail in every hearing, and it's not necessary to litigate those issues before there's a determination that the parents have prevailed. I'd also like to raise the fact that there is an established procedural framework both in Maryland's courts and in the federal courts on how to determine and award prevailing party attorney's fees. OAH does not have any such framework. Furthermore, any judgment that would be necessary to enforce an award of fees would require a parent still to go to either federal or state court in order to obtain that judgment. Another issue of concern with the language in the bill is that there are situations under the IDA where the school system can petition for prevailing party fees. But House Bill 140 only contemplates the award of fees to parents. If House Bill 140 was equitable, it would address both fee shifting scenarios, ones in which the parents might prevail and ones in which the school system might prevail. In closing, I'd like to address an issue that was raised in support of the bill, which is contingency expert fees.
Thank you, sir.
May I conclude?
Real quick, yes.
Contingency experts are not allowed under the law. There is clear case law on this issue.
Okay.
Experts cannot make their testimony contingent on payment.
Thank you, sir.
Thank you.
Next, please.
Hi.
Either order. Either order.
Very quickly.
Sure.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Renee Spence, here for the Public School Superintendents Association of Maryland. We respectfully oppose House Bill 140, administrative proceedings and judicial actions, attorneys and expert witness fees, and related costs. I do want to sit here and say that superintendents consistently place top priority on meeting the needs of all their students. We have concerns with this legislation because as we read it, it was inconsistent with current state and federal education law. Currently, laws allow parents to recover expert witness fees through district courts. So there were some issues and discussions around the bill, around the way the bill was written. I know legislation passed regarding a special education study on due process. I'm wondering if this issue can be folded in with that study to possibly look at prevailing party being paid expert fees, reasonable costs, whether it should be the OAH or a district court. Maybe that would be something the study could include. That was my suggestion. With me here today is Sally Farr, because I thought it would be good to hear from a special education director who's in a local public school system and would be able to answer any of the questions the committee may have. So in conclusion, I suggest including this in the study and respectfully request an unfavorable on the bill.
Thank you very much. Ms. Farr, want to bring us on home?
Yes, good evening.
Thank you.
My name is Sally Farr, and I'm the Director for Cecil County Public Schools Special Education Program. I have dedicated the past 41 years to working with students with disabilities and, more importantly, their families. Individuals that enter the field of special education are dedicated to providing the supports and services to our students. Cecil County prides themselves in resolving parental concerns through IEP meetings, through the mediation process, and through resolutions. Throughout the years, CCPS has been extremely successful in resolving these issues. Due process, as we heard tonight, is extremely taxing on the county emotionally and financially and the families. A hearing removes teachers and related service staff from providing services to their students for days and possibly weeks. Substitute teachers and related service staff are required, which places a financial and instructional issue on the county. The hearings are adversarial with the goal of discrediting teachers and staff. Teachers, related service staff, and qualifications are questioned, causing emotional stress. More importantly, the relationship with the family is severed. Regardless of who prevails in the hearing, emotional and relational damage occurs. House Bill 140 may discourage parents, guardians from seeking to resolve matters prior to filing a due process hearing in hopes of receiving a full award of attorney fees, which is not guaranteed, and expert witness fees. In our last due process hearing, the parents' attorney's fees were $373,976, which equates to 6 full-time teachers or related service providers or 12 paraprofessionals. This figure does not include payment of our attorney, substitute teachers, or substitute related service personnel. House Bill 140 may increase the number of due process filings and increase the number of appeals by local school systems, thus increasing the cost of litigating matters. CCPS opposes House Bill 140.
Thank you very much. Any questions of the committee? Seeing none, that concludes the public hearing for this bill, and it does conclude the public hearing for today.